Well, good morning, everyone, and welcome back to COS Live. I'm Rita Peters. I'm the Senior Vice President for Legislative Affairs with Convention of States Action, and I will be your host for this morning's edition. Andrew Luce, my regular co-host, is in a different time zone. It's a little bit too early where he lives, so I'll miss him this morning, but we've got an exciting event to cover for you this morning. In just a few minutes, we are expecting a public hearing of the Kansas House Committee on Federal and State Affairs in consideration of our Article 5 application. And in Kansas, you will hear that referred to as SCR 1604. 19 states have already passed our resolution calling for an Article 5 convention for proposing amendments to the U.S. Constitution on three topics: fiscal restraints, limiting federal power and jurisdiction, and setting term limits for federal officials and members of Congress. We need 34 states to get to that convention, and Kansas is right now in the driver's seat to become state number 20. So, how did we get to this point? Well, if you've been with us for a year or more, you may be thinking, didn't Kansas already pass the COS resolution? And you would be right. We did pass through both houses of the legislature last year by a simple majority vote, which in most states is what is required. However, there's a rule in the Kansas state constitution that Article 5 applications must achieve a 2/3 threshold. Now, we believe that is unconstitutional, and there's plenty of legal authority that supports the fact that that is unconstitutional. So, right now, there's actually litigation pending in Kansas. It's making its way through the courts, was filed by a group of state legislators challenging that provision in the Kansas state constitution. But while it's pending, the best we can do is to move forward and just work on getting that 2/3 supermajority requirement that is still present, still pending in the Kansas state constitution. Last month, the Kansas Senate achieved a huge victory, actually successfully passing our resolution with the required 2/3 vote. In fact, the vote was 29-11, a resounding victory in Kansas. And that was the first time in Kansas that our Article 5 application ever achieved that 2/3 threshold. Nearly 50,000 Kansans have signed the Convention of States petition, letting their legislators know that they want them to vote yes on Convention of States. Now, today's hearing will feature testimony from the public. You'll hear from our grassroots supporters there in Kansas, and you'll also hear from Michael Ferris, Senior Advisor to Convention of States and true expert on all things Article 5. He will give testimony remotely. He is standing by, logged in, ready to speak. Michael Ferris has actually litigated an Article 5 case in the federal court system. He's also written a peer-reviewed research article published in Harvard's Journal of Law and Public Policy, vindicating the 1787 Constitutional Convention, proving that no, it was not a runaway. Now, no vote is going to be taken in this committee today. This is just standard practice in Kansas. We do expect the committee to vote later this week. And in fact, I suspect that that vote might happen tomorrow. So stay tuned. We'll do our best to bring live coverage of the committee as they discuss and debate among themselves and make their vote on our Article 5 application. A successful vote in this committee would prompt the resolution then to go to the full House for a floor debate and vote for Kansas to become the 20th state to join the Convention of States movement. And again, because the litigation in Kansas is still pending, the Speaker of the House will only rule the resolution to have passed the full House if they get a 2/3 supermajority vote in the House. That is a very tall order. I don't know if we will get there. I know that our team is working hard to get there, but that's just because we're still waiting on the court to rule on the litigation that's pending out there in Kansas. So we'll take you to Topeka in just a moment. I know producer G is monitoring the live stream feed there from the Capitol in Kansas. And I want you to stay tuned after the hearing if you can, because we're expecting Regional Director Deanna Beckett to join us for her reaction and to issue a call to action. Deanna has been no stranger to COS Live this year because she's had a lot of the states that have already held hearings and debates. A lot of her states have just moved the resolution early. So looking forward to hearing from Deanna again and catching up with her. Now, let me give you a quick national update. We have had 3 chamber victories already this year. Both the South Dakota Senate and the Wyoming Senate have passed our resolution. Let me give you those votes. In Kansas, the Senate passed by 29 to 11, again, achieving that 2/3 supermajority vote. In South Dakota, we passed the Senate with a vote of 23 to 9 with 3 members absent. That is a very helpful graphic that producer G's got there for you. In Wyoming, the Senate, another supermajority vote, 22 to 7 in the Wyoming Senate. Now, unfortunately, the House side in both South Dakota and Wyoming did narrowly reject Convention of States. So we didn't make it across the finish line in those 2 states this year. But having those House floor votes in hand does let our team know exactly where the legislators are who need more persuasion, who need more education about Article 5, so we can get them to a yes for the next session. Now, right now, we're still awaiting action by the New Hampshire House of Representatives and the Iowa House of Representatives after seeing victories in committees in both of those bodies a little earlier this year. Last week, Ohio held a hearing on the Senate side. The committee heard public testimony in favor of our COS application. They have not voted yet. We are awaiting the scheduling of the next committee hearing there in the Ohio Senate. That hearing will be the one where we have to listen to only opponent testimony. So if you can handle the frustration, if you can handle listening to lots of false information being spread and wild fears and speculation, then join us for that committee hearing. That should be a fun one. So that's Ohio, still pending, still moving forward there. Now, thus far this year, a total of 20 states have filed our Article 5 application for consideration this year. So, producer G, there's the graphic again. So, our resolution has been introduced in Connecticut, Hawaii, Idaho, Illinois, Iowa, Kansas, Kentucky, Massachusetts, Minnesota, Montana, Nevada, New Hampshire, New Jersey, Ohio, Rhode Island, South Dakota, Texas, Vermont, Washington, and Wyoming. And of course, 19 states have already passed the resolution. And you can see those states listed there in green. All those states in green have already passed our COS application. And folks, I can give you a little bit of behind the scenes information that's coming to me right now from Dave Schneider, who is on the ground there in the committee room. If you've been with us a while, you may remember Dave. He used to be a regional director for us, and he is still working hard for us in his home state of Kansas this year. Dave just texted me to say that our folks will have about 20 minutes total to testify. So this won't be a 3-hour long hearing like some that we've had this year. Idaho comes to mind. Mike Ferris will be up to give his expert testimony after a few local grassroots supporters, and Mike should have about 10 minutes of that 20 minutes time. Mike, of course, the author of the legislation and subject matter expert. So they give him a little bit more time due to his expertise. Also, typically, the committee members will direct any questions they have about Article 5 or about the application to whoever is appearing in their capacity as an expert. And, this is a great benefit for us of having our experts available because we want the committee members to get good information about the Article 5 process. We don't want them to be left thinking there are questions, that we don't know how the process works, because it's true that we've never had an Article 5 convention for proposing amendments in American history. But that doesn't mean that we don't know how the process works, because while there's never been an Article 5 convention in American history, we've had scores of other types of interstate conventions. In fact, we know that's why the founders included the convention process as the way for states to lead in proposing needed amendments. They didn't want to just give the power to Congress because they were suspicious of centralized power, and they knew that one day Congress might become overbearing, might start to abuse its power. They wanted states to have a way to propose amendments, and they were familiar with the process of interstate conventions, which is just the way that states would meet together to resolve particular issues, work out solutions to particular problems. And so they made the other route for proposing amendments through this interstate convention process. So we know how the process works. And of course, Michael Ferris, as an expert, can speak to all of that. Um, Commenter Melissa Martin on YouTube is asking, how many more committees does it have to be heard in? Well, in Kansas, this would be the last committee because we've already had our committee hearing on the Senate side, which we passed. Then we passed the full Kansas Senate by a 2/3 supermajority. So now that same legislation, SCR 1604, has moved to the House side where it goes through the same process. So we'll have this one committee hearing in the Kansas House. And if we pass this committee, then we'll go to the full House floor for a vote. Now, if you're asking about how many more committees it has to be heard in across the country, well, the typical process is that is the next stage after the application is introduced. Okay, it looks like the committee is starting, so we're going to take you there now.
The bill introductions will move on. We're going to open up a hearing on SCR 1604, and Mike will get us started on that.
Mike Heim with the Revisor of Statutes Office. Mr. Chairman, members of the committee, Senate concurrent resolution passes Senate, I think, 29-11. It's the committee's heard several of these this year, and I think this is the broadest one. What it provides is that the legislature of the state of Kansas applies to Congress under the provisions of Article 5 of the Constitution of the United States for calling a convention limited to proposing amendments to the Constitution that impose fiscal restraints on the federal government, limit the power and jurisdiction of the federal government, and limit the terms of office of officials and members of Congress. So it's a little broader than some of them. But anyway, this is another concurrent resolution calling for an Article 5 convention.
Committee, any questions for Mike? Representative Sanders?
Thank you, Mr. Chairman. If it makes it out of committee and gets to the floor, how many votes does it need to pass on the floor?
That's a really good question. There's a lawsuit arguing that, I think, still. And the position of the revisor's office is that it requires 2/3.
Thank you. Thank you, Mr. Chairman.
Any other questions? Not seeing any. Thank you, Mike. First up on in person, we have Bob Strouder. Is Bob here? Welcome to committee.
Thank y'all. I'm just going to read this because that way I get it right. One day about 12 years ago, a few of us guys happened to get together and the conversation got around to complaining about the way things were being handled in Washington, D.C. After a while, Eric, later to become Representative Eric Smith, told us we needed to have an Article 5 convention of the states. I didn't know what he was talking about at the time, but didn't say anything. I filed it away in my head as something I probably ought to look into. At that time, I was still driving a truck, and while at a fuel stop, I wanted to get some coffee. There were some men hanging around complaining about the government. And one of them said something like, "How much longer do you think people will put up with this before we have another civil war?" And that bothered me a lot to hear that. And the only time in recorded history that a war of this type has ever reduced the size of government was our American Revolution. And I'm pretty sure the only reason that is because George Washington didn't want to be a king. And war is not the answer. A short time later, I came home to find Kim, my wife, upset about things she'd heard on the news. Without going into details, it was more of the same kind of government overreach that mentioned earlier. After we discussed it a while, she said, "All I ever hear is a lot of talk and nobody does anything." I realized it was time for me to get more involved. Remembering what my friend Eric had said that day, I Googled Article 5 convention and found Convention of States project, started by Citizens for Self-Governance by people like Michael Ferris, Mark Meckler, and endorsed by Mark Levin. I saw what they were trying to do, and I read Article 5 a couple times, and I wondered why we haven't already done this, and became a volunteer for Convention of States. I've been coming up here regularly since 2015, doing my part to get the Kansas legislature to do theirs. The U.S. Constitution and especially Article 5 make it clear that the states are to be in charge. I ask you to pass SCR 1604 to the floor and help make Kansas an applicant for an Article 5 Convention of the States. Thank you for hearing me.
Committee, do we have any questions for Bob? Not seeing any. Thank you, sir.
Thank you.
Next up, we have Ben Terrell. Ben, welcome back to committee.
Thank you, Chairman Kessler, and good morning, committee. Well, my name is Ben Terrell, and I am the volunteer legislative liaison for Convention of States here in Kansas. And I have been in that volunteer role since late 2018. I represent tens of thousands of Kansans, of your constituents and fellow citizens who have signed our petition, and dozens of active volunteers like myself. When I signed the petition in January of 2016, we had all of 6,500 petitioners approximately in Kansas. Today, there are over 47,800 petition signers in Kansas. So that's 9 years ago. My point is we're a large and growing grassroots organization. Thank you for hearing testimony on our resolution today. We asked you to hear it because all of us have become distressingly, have come to the distressing conclusion that finding the best candidates and voting them into office in Washington doesn't do the job. In fact, it fails to secure our rights in the Constitution from the federal government. We find that the government in Washington has, in fact, become an enemy of our liberty, and that the vested interests there are not interested in changing course or letting us have our liberty back. We ask you, therefore, our state legislators, to help restore Lincoln's vision of government of the people, by the people, and for the people. How can you help us do that? The framers provided a way for any power in the federal government to be checked by another. The way to restore our liberty from the federal government is for the states to intervene and do what they are duty bound to do through Article 5 of the Constitution. There you're authorized to initiate amendments as co-equals with Congress. When 2/3 of the states, which is 34 out of 50, pass resolutions on the same subjects and then meet to deliberate and draft amendment proposals. I'm sure you remember that any amendment proposals, whether initiated by Congress or initiated by a state convention, have to be ratified by the states. You remember that job. And that would be a ratification requirement of 3/4, which is 38 states. You've always known that has generally been forgotten since about the 1980s, that you have an equal right with Congress to initiate amendments. It may help you to know that the Kansas legislature is not a stranger to this process, having passed 8 resolutions for amendment conventions between 1907 and 1978, 2 of which are still active. One from 1951 for limits on the federal taxing authority to 25% of whatever it is they tax, and another from 1978 for a balanced budget amendment. Our proposal has been brought to this committee several times beginning in 2015, so 10 years of experience. It has passed favorably out of this committee on all but one occasion. And 3 of those resolutions were then heard on the House floor. In 2016, the resolution was lost on a vote of 77 for and 47 against. That's roughly 61 and some percentage for. The 22 resolution was lost on a vote of 76 for and 43 against. And in 2023, the resolution lost on a vote of 74 for and 48 against. This is to give you some history, context, and background. We ask you to use your authority, again, to oblige the federal government to control itself. Take action so that Kansas can join the 19 other states that have passed similar resolutions already, so that we can bring us closer to the 34 needed to actually call what is simply a meeting of the states. We have interstate meetings all the time to draft amendment proposals, which will then come back to you for your approval and hopefully get us on to restoring a more constitutional order for our government.
Committee, are there any questions? Representative Sanders.
Thank you, Mr. Chairman. Thanks for being here, Ben. So is there any concern that these 3 areas are a little too broad and not specific enough?
No, there isn't, because if you go to the trouble to have a convention of states, you don't want to walk away having done not enough, but to the fear of doing too much. Here's the thing. The topics are impose fiscal restraints on the federal government, number 1. Number 2, limit the scope and jurisdiction of the federal government, and I'll come back to that one. And finally, impose term limits on federal officials, including members of Congress. Now, Congress isn't going to impose term limits on themselves. They've tried and failed. They've imposed successfully term limits on the president, and the states ratified that. Are they ever going to impose a balanced budget or any fiscal restraints on themselves? No, they've tried and failed on that too. So things that limit their power, they're not interested in. And that's the genius of our system of federalism. Again, you are the check on federal power. Rather than letting them continue to spend $3 trillion in excess of what they take in every year, you can say, no, we have to balance our budget here in the Kansas government, and the federal government ought to do the same. So back to the second point, what we mean by limiting the scope and jurisdiction of the federal government is not, is specifically, we would like to see some federal Supreme Court decisions from the 1930s that expanded the scope, that amended the Constitution, where it says in Article 1, Section 8, the Congress shall have power to regulate interstate commerce. Those 3 court cases expanded and said anything that might go into interstate commerce at some point, somewhere, at some time, far, far away, in a galaxy far, far away, are regulatable by Congress. And so therefore today, the light bulbs in these fixtures are regulated not by you, not by us, the people. Nobody takes a vote, but they're regulated by a bureaucracy in Washington, D.C. called the Environmental Protection Agency, or anybody else who wants to pass a regulation. So we think that ought to be changed.
Mr. Chair, if I may. So take us through the mechanics of this. So let's say that 2/3 of the states agree to call an Article 5 convention. What happens then? How does it get going? Who decides where it's going to be, when it's going to be, that sort of thing?
Thank you, Representative Sanders. Yes, it's not a mystery. The United States has a history of over 40 conventions, a rich history prior to and during the colonial period, and that's why the founders used that term in the Constitution. They all knew what it meant. It's kind of like trial by jury. It's spelled out in the Constitution, whether that's 12 people, 6 people, etc. Everybody knew what it was, and so that is continued forward. So what happens is, once we get to 34, the Constitution in Article 5 simply says Congress shall, not may, but shall, we all know that that means they have to, call a convention of the states. And all that means is they're going to name a date and a place for the states to gather. The states, you all decide how many delegates you're going to send and how they're going to be qualified and how they're going to determine how they vote and other things like that. There was a process bill that came through here earlier this year, HB 2065, if you want to make note of it and look it up. It's, last time I looked, it was 4 below the line in the House. That's the kind of thing that you do. You decide how you're going to select the delegates. All the states do that. 20 states, over 20 states have already decided that, how many delegates they're going to send. But once they get there, one state, one vote, because it's a convention of states, not of people. And they've always followed that rule. And all 40 of these interstate conventions have never run away from the agenda that's been placed before them by the states.
Thank you. Thank you, Mr. Chair.
Representative Wagner.
Thank you, Mr. Chairman. Mr. Durrell, I guess one of my questions is just regarding, I'm very familiar with the Convention of States Action folks, which have been kind of the folks, I think, on a national basis that have been pushing this. But we've had like other Convention of States, resolutions and whatever. I mean, what is your opinion of that? Is that distracting or confusing, or does that sort of irrelevant to the overall goal of getting an actual Convention of States?
No, I would say it's not distracting. I would say it's helpful, because whether they're they're trying to limit the federal government, such as U.S. term limits, or whether they're trying to limit campaign financing, such as the Wolf Pack organization. So, whether they're predominantly one party or another party, they all look back to the Constitution and see a solution there. And the solution is exactly what Washington wants you not to do. They want you to take their money, which comes from our pockets just the same as your taxes, and they want you to look the other way and keep that gravy train rolling. So I think it's good to use the Constitution. You all swore an oath to uphold it. I've not been in the military or in the legislature, but I try to uphold it myself. Thank you.
Representative Smo.
Thank you, Mr. Chair. I'm just wondering how many other states currently have this particular call?
19.
19.
Right.
And how many do we need?
We need 34, so we're more than halfway there, having passed 17, but we need 15 more.
All right. Thank you very much.
You're welcome.
Representative McNorton.
Thank you, Mr. Chair. This might be a question actually for the reviser, but the HCR 5001, which was specific to term limits, if we pass this, what takes Trump, or how's all that work?
I think Mr. Ben could probably answer that for you.
So the question, Representative McNorton, was about the term limits resolution. Okay, that has not come up for a vote yet in the House floor, has it? Okay, it'll be just determined in the normal way by what gets put above the line and what gets voted on. This resolution, let me just say, has passed the Senate by a two-thirds majority, 29-11 on February 27th.
Thank you. So your estimate or your think that only one of these will come up on the floor, both of them won't pass?
Well, I don't know.
Okay.
What
What if both of them would pass? Which one is?
In some states they have. Both have come before the body and both have been voted on. Again, we believe in our three-legged stool approach. We believe that to properly restore constitutional order to Washington, you need more than term limits. You need to cut off the money, you need term limits, and you need to go back to the constitutional definition of commerce instead of what was gone to in the 1930s. When we were in a depression, and that is not constitutional, and that nobody ever voted for. Just 9 people in black robes decided that was best for us. And we don't think the outcome has been good.
Okay, thank you.
Not seeing any more, Mr. Terrell. Thank you.
Thank you.
Next up, I have David Schneider. Welcome to committee.
Good morning, Mr. Chairman, members of the committee. My name is David Schneider. I've been working on this particular legislation now since its inception. I think I was a volunteer, one of the very first in the state of Kansas as the first state director volunteer back in 2013, and since went to work for the organization for about 10 years. And now no longer work for the organization, as I'm a lobbyist here in Topeka, and they're one of my clients because I know this legislation extremely well. I would like to defer the rest of the time to a subject matter expert. I think they're on WebEx. Is that correct, with Mike Ferris? Any other further questions? This is the author of the original legislation and the founder of Convention of States. So he's a subject matter expert if there's any other questions that might be out there. So, but I'll stand for any questions as well.
Committee, any questions? Not seeing any. Thank you. And that's going to take us to Michael Ferris on WebEx. Are you with us, Michael?
I am. Can you hear me?
We can hear you loud and clear.
Okay. Mr. Chairman, members of the committee, thank you so much for the opportunity to be here today. I take you back to the last week of the original Constitutional Convention in 1787. George Mason stood up on the floor of the convention and said that the current proposal that was in front of him at that time to only allow Congress to propose amendments to the Constitution would not work in the case where the federal government was abusing its power. And he said that the states need to have the ability to also propose amendments, or else we would never get amendments that would limit the power and jurisdiction of the federal government. And because he predicted that someday the government would abuse its power. And without debate, without dissent, the current version of Article 5 was passed as an amendment to the then Constitution, and it became final ultimately about a week later. And so we now have in front of us the history of Article 5. There have been 450 applications for a convention of the states on various topics. And by the way, if a state or any state passes more than one convention of the state application, they're independently counted. It has no effect on the other. And so whenever one of these topics gets to 34 states, then you have a convention on that topic, and the state can join more than one at any time, or two or three, or whatever it wants to do. They're completely independent. And so, but 450 applications have been passed in the history of their country. Most of those are still valid, but the reality is we've never gotten to 34 states, or 2/3 of whatever the number was at the time, 2/3 of the states on any particular topic. The agreement on the topic is like setting the agenda for a committee hearing. You have to agree on the topic ahead of time. And the decision on what the topic is binding throughout the process. And so the question before us all is George Mason's condition for having a convention, is it before us? Is the federal government abusing its authority? We can just look at a couple of factors regarding the bureaucracy. There's so much we could say that's abusive, but just focus on one really important area. We have 50 books of laws passed by the United States. We have 250 books of laws passed by the various agencies like the EPA and Department of Labor and so on. So we have 5 times as much law passed by people that are not elected by the voters as we do by people that are elected by the voters, despite the fact that Article 1, Section 1 says that all legislative authority is vested in the Congress of the United States. And we're learning in the recent weeks with the DOJ committee and so on, that not only do they have essentially unchecked power, or rarely checked power, perhaps would be a little more precise, on their use of their legislative authority, their spending power is absolutely out of control. Nobody knows what they're doing with all this money. It's functionally a closely guarded secret. The ability of unelected bureaucrats to spend money at will and to pass law at will is not how a Republican form of government is supposed to work. Because whoever passes laws, whoever spends money is supposed to be accountable to the voters, and we should be able to vote the rascals out. We can't vote these rascals out that are doing this, and we need to fix the Supreme Court decisions that have ignored Article 1, Section 1, and the other articles relating to spending, so that we have fiscal restraints and we have political accountability for all these things. Now, one other generalized factor that mandates this without really much question is $36 trillion and growing rapidly in debt. And if we were to follow the general accounting principles for businesses, that number would probably be about 5 times that amount when you take all the amount that's been borrowed from the Social Security Trust Fund and so on. The amount of debt that the government has incurred is just unbelievable, and it's got to be stopped. The founders gave states the ability to stop it. They gave state legislatures the ultimate power to control what the federal government would do. And so the only question is, will you accept the responsibility given to you by the founders to make sure that the federal government is accountable and is doing what it's supposed to do. It will not control itself. My wife and I have the blessing of having 10 kids. And so I think I can speak as a subject matter expert on kids to some degree. And I have a pretty good idea what would happen if you tried to raise a kid for 18 years and never discipline them. Well, we're seeing what happens when states let the federal government go undisciplined for approximately 250 years. That an undisciplined government is out of control. And it's time for the states to impose discipline. The only argument from that we usually encounter in states like Kansas is the possibility that this might run out of control. It's a myth that the original convention ran out of control. I've written in a Harvard Journal of Law and Public Policy law review article showing that that is just a defamation against the Constitution. We can get copies of that law review article for anybody that wants it. But the short answer is it did not run away. They followed the rules that were set by the states. The states set the rules and they followed them. But moreover, with the 450 applications, we have a historic rule that the subject matter agreement is absolutely binding. And it's binding throughout the process, not just at the beginning of the process. You can't go outside the subject matter. And there's been litigation. I filed the very first case on this topic ever in the history of the country when I was a very young lawyer on the Equal Rights Amendment, when Congress tried to manipulate the process for ratifying the Equal Rights Amendment by changing this stated deadline of 7 years to add another 3.5 years. And that litigation was successful, and recent versions of that litigation have also been successful. We've found that you can't manipulate the process. You got to follow the rules that brought you to the table throughout the process, and that's been rehearsed and reinforced time and again with the ERA litigation. Finally, the fact that 38 states have to ratify, which means if 13 states vote no, one House and 13 states vote no, or 13 states don't even vote, you have to get affirmative votes from 38 states. And the ability to get something crazy through that process is just not realistic. Bills get filed all the time in Congress and in state legislatures that everybody in the world knows will never see the light of day. And the reason is they're crazy. And crazy stuff does get proposed, but crazy stuff ultimately does not happen when you require 38 states to ratify it. It's very difficult to do something good. It's impossible to do something crazy. And so with that, I'd be glad to answer any questions that you might have. And just thank you for the opportunity to be here remotely, Mr. Chairman, and members of the committee. It's an honor to be with you today.
Committee, any questions? Representative Clayton.
Thank you, and thank you for appearing before the committee. One of the questions that I have and that I've been thinking about throughout this hearing is that isn't this a little bit redundant? One of the things that we talk about with Convention of States is out of control spending, but with the advent of Elon Musk and the Doge Committee, it appears that they are cutting this spending. So isn't this now redundant because of that?
Well, Mr. Chairman, Representative Clayton, thank you for the question. Well, let's assume that Elon Musk is completely successful. There's a lot of litigation, and so there's questions yet to be answered about whether that process can be used effectively. Whatever it is, it's temporary. It will be, at best, what this administration does. What we can do is put permanent rules in place. Permanent rules such as every grant that an agency gives has to be officially published and available for the whole world to see. That kind of transparency would do away with a lot of the nonsense that we're seeing. And so we can make not just guiding principles, but binding rules that are put into place forever. And we can make sure that the spirit of the Doge process lives on in binding law that can't be successfully attacked by multiple court hearings. When you put it explicitly in the Constitution, it'll be enforced.
Well, and I think that we can all agree that we don't like unelected bureaucrats spending out of control, and we don't like unelected bureaucrats cutting out of control either. The control needs to be with elected officials who are accountable to the people. Thank you, and I appreciate you expressing the spirit of this legislation.
Representative Lewis.
Thank you, Mr. Chair, and thank you to the conferee. I have a question about if we were to pass this resolution, does our approval ever lapse? In other words, 20 years from now, is it still Kansas's approving of having the convention for, let's say, term limits?
State can and a few have put time limits on their applications. And so basically whatever rules you establish would be still in place. An ultimate check is that Kansas can eventually rescind what Kansas has done. For example, there are 13 states right now that have viable applications for a right to life convention. If my memory serves me correctly, Massachusetts is one of those states. Now, if you actually got close to 34, I guarantee you that the Massachusetts legislature would rescind its application. It wouldn't count. So you have the ability, once something gets close to 34, if the legislature no longer agrees with it, it has the ability to rescind it. And up until the time you get to 34, your power to rescind is plenary. You can do whatever you want up until 34 have actually agreed.
Thank you.
Representative Smo.
Thank you again, Mr. Chairman. Michael, thank you for being here. And my question is, if the entire concept of this is that we are not abiding by the Constitution as it's written as in good faith, then calling the convention, how can we assume that we're going to abide by the changes? What will that entail? What do we have to do to ensure that we not only are abiding by the original Constitution, but the changes that we are looking to make?
Mr. Chairman, thank you for the opportunity to answer the question. I have said myself, I taught constitutional law at the collegiate level for 17 years, and I would loosely say we don't follow the Constitution. That's really not precise. The precise way to say it is we're not following the original meaning of the Constitution in several respects, but we are following the Constitution as interpreted by the Supreme Court. That's a fact. Now, we have amended the Constitution, and the more specific we can make the amendments, the easier it is to make sure that they're followed. For example, we amended the Constitution for term limits on the president. We follow that. We amended the Constitution to give 18-year-olds the right to vote. We follow that. We amended the Constitution to make sure that you can't be denied the right to vote on the basis of race. We follow that. And so the specifics are good. So one proposal that would be germane under our resolution would be to make sure that there are only 9 justices on the Supreme Court, because Congress can currently set the number at whatever you want. And one way to reduce the power of the federal government is to take away the power of Congress to do court packing. If we did that, it would be binding and it would be followed. And so the more specific you write a resolution, the better off you are in making sure that it's followed. But the amendments have a great history of success. We follow them, and the more precise, the better. But we can put steps in place, like on fiscal restraints. The more you specifically tie down the definitions of terms, the more specifically will have to be followed. And I think we can do a great deal to make sure that the federal government has a much more difficult time of getting out of control again.
Thank you.
Representative Sanders.
Thank you, Mr. Chairman. So does SCR 1604 mirror what is currently in court trying to be decided whether or not we need a 2/3 vote or a simple majority for it to pass? And if it mirrors it, is this necessary?
The short answer is it is necessary, because the litigation that's ongoing that I'm lead counsel in, if we win that litigation, it is a declaratory judgment that the Kansas Constitution cannot supersede the U.S. Constitution in the process, setting the process for proposing amendments to the Constitution. But even if we won the litigation, it doesn't mean that it's passed, because the same exact bill did not pass the House and the Senate of Kansas. The same operative language passed, but not the same legislative vehicle. And under your rules, you actually, and the rules of the Constitution of the United States as well, you have to pass the same exact legislative piece of legislation. So passing parallel legislation in two houses, but neither bill crossed over to the other house because the presiding officer of each house under the Kansas Constitution ruled them to not pass because of the lack of 2/3 majority, even though the majority clearly supported it, the lack of a 2/3 majority. So it's not redundant at all. The only way to moot anything is for this House to pass this resolution by a 2/3 majority, and then the question goes away. The litigation would then be moot, but otherwise, we're just simply waiting for the federal district judge to rule on the case. And he will decide whether or not the Kansas Constitution can be used in this way, but it will have to be voted on regardless, no matter how that litigation comes out, it'll have to be voted on again.
All right, now we also currently have a delegate selection process working its way through our system. If that gets to the floor, does that definitely require 2/3 or definitely only require a simple majority, just the delegate selection process?
This is my opinion, and you will need people that are more official in your process to get there. But I don't believe that it falls under your state constitutional provision. That is an act of the Kansas legislature using the power that you got from the Kansas Constitution. And so because you're passing an ordinary law. And so an ordinary law, it is not actually calling for a convention, nor is it ratifying a constitutional amendment. So my opinion is it follows the normal rules of voting in the Kansas Constitution, which I understand to be a simple majority in both houses.
Simple majority and signature of the governor, correct?
That's correct. Yes.
All right, thank you. Thank you, Michael. Thank you, Mr. Chair.
Representative Wagner.
Thank you, Mr. Chairman. Mr. Ferris, really appreciate your testimony. This 2/3 barrier that Kansas has, if we wouldn't have had this, this bill or this resolution would have been passed, 8 years ago. My question is, how many other states have this sort of 2/3 hurdle? I mean, it seems like, in my mind, it's very daunting to get, 2/3 of the states or 3/4 of them to pass a convention of states. But most of the states where it's already passed, it's just been a majority. But how many other states have this 2/3 language like Kansas does?
Only Illinois has this. You're the only two states. And of course, Illinois has not passed this resolution. It's not one of the 19 states, so it has not come up.
All right, thank you.
Representative Lewis.
Thank you, Mr. Chair, for indulging me one more question. I'm going to ask about the litigation that you're lead counsel in. Procedurally, where are you? I know I think you're in the district court, and is the matter sub judice, or is there still briefing and or argument to be had before it's in front of the judge for decision? And then sort of follow on to that, I'm assuming, but correct me if I'm wrong, that whichever side loses will take an appeal to the 10th Circuit, and it may go on to the Supreme Court. Is that accurate?
It's mostly accurate. The case has been submitted to the judge on briefs. There's no briefing left. We've resubmitted a request for oral argument. The judge has not scheduled hearing for it. So we're just waiting on the judge to act. Whether he acts next by issuing a decision or by scheduling oral argument is entirely up to the judge, completely within his discretion. Both sides would have then, of course, have the ability to take the matter further. Whether or not we would certainly take it up if we did not prevail at this stage. Whether the Kansas Attorney General does or not is something that they would have to answer. I don't know. And And again, the ability to take it to the Supreme Court of the United States is a possibility. I would say that there are at least 6 decisions of the Supreme Court of the United States that have held that state constitutions cannot be made applicable to the process of amending the U.S. Constitution. So if the 10th Circuit if the 10th Circuit ruled in our favor, I don't think it's automatic that the Supreme Court of the United States would take this case, because it's yet one more example of the same rule that state constitutions can't be used to amend to control the process of amending the U.S. federal Constitution.
Not seeing anybody else. Thank you, Michael.
Thank you, Mr. Chairman.
Committee, I'd like to go ahead and point out that we do have some written proponents as well on your S drive. I don't have any neutral, written or oral listed. And moving over to, on the opponent side, I do have John Extel in person. John, welcome back to committee.
Good morning. Thank you, Chairman. Honorable Chair and Committee, I'm John Axtell from Wichita, and I'm the volunteer coordinator for Kansas Campaign for Liberty. I oppose SCR 1604. Now, the proponents claim that this process can be constrained, but that's not the case. Recently, on the floor of the Kansas Senate, in the debate on this resolution, the carrier was asked, quote, Gavin Newsom has called for a convention of states for gun control. So could they take that up at this convention of states, end quote. And the carrier responded, quote, in this particular one, there are 3 topics that are germane. And again, yes, there could be that topic, end quote. Gun control could be a topic at this convention. Pro-abortion amendments and socialized health care amendments could also be fair game. How do we know this, other than what the carrier said? The Supreme Court has already decided that states will have no control over the amendment process. In the 1939 Supreme Court case, Coleman versus Miller, which just happens to involve Kansas, Justice Black, in the concurring opinion, said, quote, Congress, possessing exclusive power over the amending process, cannot be bound by and is under no duty to accept the pronouncements upon that exclusive power by this court or by the Kansas courts, end quote. The Supreme Court itself said not only do the states have all authority, but even the Supreme Court has no authority over the amending process. Congress will run the show. The words in this Kansas application will not constrain the topics. Delegate bills will not constrain delegates, not in the eyes of the federal courts. And if we want to see what Congress has in mind, let's take a look at HCR 24, a resolution from the 118th Congress, the last one, which would have called a constitutional convention under Article 5 had it passed. It states that Congress will aggregate applications containing a broad range of language in tallying the 34 required states. So there could not be precise control over the topics covered at a convention. Again, this will be an open convention. And furthermore, since Congress possesses exclusive power over the amendment process, Congress has the power over the final ratification. HCR 24 called for ratification by state conventions of we the people, and not by the legislatures This opens the door to ratification being controlled by the most radical elements or factions in each state. Let's calibrate ourselves on how that might work. I personally was very sad to see the defeat of the Value Them Both Amendment here in Kansas. That defeat was horribly decisive, and if anything, shows that a pro-abortion amendment could pass even in Kansas under the right conditions, such as a ratification convention, possibly. I'd also like to address one comment made by Mr. Ferris about the Kansas Constitution not superseding the U.S. Constitution. That is not a valid claim if the reference is the 1975 Dyer versus Blair case, which was cited by the Attorney General in his letter and so on. I'm certain that this is a basis for the lawsuit made by the two plaintiffs and that was discussed just a moment ago. The Dyer versus Blair case was very, very clear, and it said that the state legislature was free to accept or reject, and those are the words of the Dyer case, the words of the Dyer court. They were free to accept or to reject the supermajority requirement in the state constitution. We've talked about that before. But I want to put to bed any claim that the Kansas Constitution is not constitutional, because the Kansas Constitution is absolutely constitutional in its 2/3 supermajority requirement. The question is, do you want to follow that or not? And the Dyer court spelled out the conditions by which you didn't have to follow it, and the Kansas legislature is proceeding down that path. That's what's happening. The Kansas Constitution is constitutional in this regard. So in a constitutional convention, everything will be different than what the proponents suggest. And the Supreme Court says so. And the truth is, this will be an open convention. Gun control, abortion, and other horrible topics could be on the table. The truth is that Kansas will have no control over delegates or topics. The truth is that Congress has exclusive power over the entire amending process, and that ratification will very likely be by state conventions of we the people. This is a very bad idea. I urge you to vote against SCR 1604, and thank you for your consideration. I'll be glad to stand for questions.
Committee, any questions? Representative Reese.
Thank you, Mr. Chairman. And Mr. Axel, thank you for being here today. Something kind of stuck with me last time you spoke. By virtue of our oaths to the Constitution of the United States and the constitutions of Kansas when we are sworn in, that these type of going to the Convention of States and distorting the Constitution as we know it today, is it in violation of our oaths? Could you elaborate on that, or was that something that I remember you saying?
So I want to make sure I understand the question. You're saying when we make an oath to adhere to, support, I think is the real word, support the Kansas Constitution and the U.S. Constitution, are you asking if by applying for a convention of states, are we actually performing that function?
No, that's my deal. We are in violation of our oath.
Yes, I don't believe that applying for a convention of states, I'll be real honest, I don't believe that that is a violation of the oath. I do believe that the lawsuit, in fact, I'm certain that the lawsuit is a violation of that oath. And voting for anything that enabled the lawsuit, such as the rules changes that enabled the lawsuit, I believe that's a violation of that oath as well, because it was done to enable the violation of the Kansas Constitution. Did that answer your question?
Yes, thank you.
Okay, thank you.
Representative Sanders.
Thank you, Mr. Chairman. So your position is Congress has sole control over the amendment process to the U.S. Constitution. Is that your position, yes or no?
That's what the Supreme Court has said.
So is that your position, yes or no?
I don't like that.
I don't care whether
If
you
you're
like it
asking
or
me what I
not.
like,
Is
I
that
don't
your,
like that.
I'm not asking what you like. I'm asking if that's your position, that Congress has sole control over the amendment process.
I'm certain that if you asked the U.S. Supreme Court.
Okay, so you're not going to answer that. So here's my other
Yes,
question.
my answer is yes, but
So your answer is
you asked
yes,
me-
okay.
I'm sworn.
Then my
by
next
testifying
question would
here, I'm
be,
sworn to give the whole truth, not a simple yes or no. And the whole truth sometimes is not a simple yes or no. And the
okay,
whole truth is that the Supreme Court has stated that Congress will have absolute authority in this. And I believe what the Supreme Court has said.
so
That's the whole
then
truth.
what is the purpose of Article 5? Why does that exist? What does it do?
The purpose of Article 5 is to fix defects in the Constitution. And what the problem is right now is that the Constitution is not being enforced. And there's a simple example of that. Article 1, Section 10 in the U.S. Constitution says very clearly that no state shall allow anything but gold or silver coin to be tender in the payment of debt. And that's something that can be done right here in this state legislature, is to declare gold and silver coin tender in the payment of debt. That will be a hearing that occurs tomorrow in the Senate. And by the way, I apologize for the interaction and the way it went there just a moment ago, but I do need to give the whole truth of, in my answers to your question. But that's one clear example. Money is one clear example of how the Constitution is being violated today. Nobody pays attention to it. Gold and silver currency kept our debt almost at zero for generations. And then we allowed the Federal Reserve to be created. And from there on, the debt has skyrocketed and our money has become worth less almost every year. And since 1971, when we went off of gold and silver forever, our debt has absolutely skyrocketed, now is 1.25 to 1.5 times the GDP.
So your position is that Article 5 has nothing to do with amending the Constitution. It only has to do with fixing the problems. Is that correct?
If there are problems in the Constitution, such as slavery when the first Constitution was passed, or the lack of women's suffrage when the first Constitution was passed, and if the Congress had not called on those issues itself, then certainly one particular issue, go and get an amendment that prohibits slavery, get an amendment that requires that women be able to vote. But those are problems with the Constitution. They are not problems with the Constitution not being enforced. That's the problem we have today. We have a Constitution that's not enforced. And like I said, Article 1, Section 10 about gold and silver, that's the clearest example that I can give about this Constitution not being enforced. And it's easy to do so. It's easy to enforce that. You can do that right here in the state legislature.
So I'm really trying hard to understand your position. So are you saying that an Article 5 convention could not have been called to abolish slavery, that it would have had to been the Congress doing that through the conventional methods?
No, I just said that if Congress had not addressed that, then sure, you'd want to do that.
So then Article 5 does have to do with amending the convention, amending the Constitution.
That was a defect in the Constitution, an actual defect in the Constitution. And yes, that was the intention. There was a defect in the Constitution. It wasn't being ignored. The provision for slavery was being honored, unfortunately, sadly. It was the wrong thing. But the defect was the provision allowing slavery. That's a defect. It's not being ignored back then. It was a problem with the Constitution. That's the intention of the founders, is when the Constitution has a defect, it should be amended. If it's being ignored, it should be enforced.
Well, in my reading of Article 5, I don't see the word defect. Thanks for your indulgence, Mr. Chairman.
Thank you. I thank you for your indulgence of my answer too.
Not seeing any others. Oh, I'm sorry, Representative Wagner.
No, thank you, Mr. Chairman. Mr. Axel, appreciate your testimony, but I am where you're basically arguing that Congress would have the authority to set sort of the ground rules for the convention. But then you also seem to be saying that it would be a runaway convention. I mean, you know, we set the ground rules for various committees and meetings and such, and we have, you know, it doesn't, you know, I mean, we're just setting the ground rules. So, I mean, Congress can set, I mean, when you talk about additional topics being thrown in or something, I mean, even under your worst case scenario, that would be something that if Congress said, you know, these are the things from the various resolutions, you know, these are the 3 areas to be discussed, then you would say that then would have to be followed because, you know, Congress confirmed what the resolution stated. Am I reading you correctly on that?
Well, just to make sure I understand your question, you're asking how far out of control could this get? Or
Yes, I mean, once Congress, even under your scenario, has made the regulations, then you are accepting that, yes, the Constitutional Convention would be bound under those regulations. I'm just point of clarity on that.
Right. Yes, well, so you're asking, in a sense, what really would Congress do, and would those regulations imposed by Congress be binding?
Yes, because I think
on the
earlier you said they
convention?
would be.
Is that right?
Yeah, I mean, you are saying they would be binding, right? It's not just a free-for-all, but once Congress had sort of set, here's the ground rules for the convention, that then they would have to follow those ground rules, correct?
Well, the Congress has absolute authority over the convention, so what the Congress says goes, yes.
All right.
And the Congress has said, though, we don't know what is going to happen, but the Congress in HCR 24 said that they were going to aggregate bills under certain parameters where they described the language that would be aggregated, okay? And they talked about fiscal responsibility and plenary issues. They use the word plenary, I believe, in their description, but I can get that out if you'd like. But they gave fairly broad language for what would be considered in tallying the 34 states required for this process to go forward. And so there will not be control by this body over the language that Congress adopts for holding the convention. That's the point. And with Congress just having passed a continuing resolution that continues, in spite of the mandate that they got to cut spending, they passed a continuing resolution to continue us down this hill. I wouldn't want to trust Congress with anything right now, but they are going to be in charge. Could it be a runaway? If they give broad enough language, then those topics that are contained within that language will be germane.
But if they gave specific language, then you would agree that it would not be a runaway convention because Congress has given specific instructions.
If they gave one specific instruction, such as create an amendment to abolish slavery, you know, say we were back 150 years ago, 200 years ago, if they gave one specific piece of language like that, we might be safe. If they gave specific language like create an amendment to establish women's suffrage, we might be safe. But the language is quite broad, and even the language in this resolution is imprecise. Establish limits on the federal government. Well, the continuing resolution just established limits on the federal government. The continuing resolution is a limit on the federal government, but that limit did not go down. It went up.
All right.
And so the language is, even of this resolution, is not sufficiently precise to constrain the convention.
All right.
And Congress has already indicated they're going to broaden that language. I don't see how this is going to end well.
Anyway, thank you.
Not seen any more. John, thank you.
Excuse me.
Not having any written on the agenda, that we're going to close out this part of the hearing. Committee, I would like to point out, Cheryl did send out the minutes.
All right, folks, you have been watching the Kansas House Committee on Federal and State Affairs hear testimony and discussion about our Article 5 application titled SCR 1604 in Kansas. A quick recap. Challenge Coin winners, COS Kansas volunteers Bob Strotter and Ben Terrell testified. They gave great testimony. They did a great job, as they always do. Ben, of course, is our legislative liaison, and he's been with the team for a long time. Same with Bob Strotter. So it's great to see them there in that committee room. Ben received some questions from the committee. Then we heard Dave Schneider, longtime regional director with Convention of States and still working for us there in his home state of Kansas. He also spoke, but he was trying to conserve time for our expert, Michael Ferris, who was there and gave great and very helpful testimony on an expert basis. And Mike received several further questions from the committee. Yeah, he did a great job. One of the highlights for me was Mike saying, just pointing out that we have 50 books of law that has been passed by Congress compared to 250 books of law passed by agencies. Something is wrong there. And then he just asked the committee, is the federal government abusing its authority? He had already laid the groundwork, pointing out that that is the very situation for which the Article 5 convention process was added to Article 5 in the final days of the Constitutional Convention. The founders wanted the states to have a way to step in and correct federal abuses of power. So they gave the states this convention mechanism for proposing amendments. Mike also pointed out that Convention of States is a way of making the DOJ reforms permanent, if you will. And that was in response to a question by a committee member. Someone else asked about whether applications for an Article 5 convention lapse if they've been pending for a number of years. And Mike pointed out that no, they don't automatically lapse, although the state legislatures can put sunset provisions on them and make them expire. The legislatures can also come back in a later year and vote to rescind any outstanding applications or cancel them. And then there was a little bit of discussion about the litigation that is currently pending in Kansas. Mike did a great job of explaining why we still need to move forward with passing the application in Kansas. He did an all-around great job as expected. And the committee members did a great job of asking thoughtful questions. Now, there was one opponent there who testified in opposition, and he was representing Kansas Campaign for Liberty. One of the things that he did was taking a Supreme Court case, Coleman versus Miller, completely out of context. He basically put it up as holding that, yes, Congress controls everything about Article 5 and no one can intervene, not even the courts can intervene. Well, of course, we know that's not true because there are a number of court cases on the books deciding Article 5 issues. But the Coleman versus Miller case basically held that in the context of an amendment proposed by Congress, yes, Congress does have authority to determine whether by lapse of time that proposal of the amendment had lost its vitality before being adopted, because Congress had put a time limit on the states for ratifying it. So completely wrenched out of context. The really interesting thing was this opponent claimed that, yes, Congress controls the entire Article 5 convention process. So let's stop and just note that in order to accept that, you have to basically be saying that the founding fathers were idiots who didn't do what they set out to do, because it's very clear from the records of the Constitutional Convention that the purpose of including the Article 5 convention process in Article 5 was to let the states have a way to bypass Congress in making needed amendments. That is absolutely irrefutable. So to believe that Congress actually controls the convention is to say that the founders were idiots and failed to do what they set out to do in Article 5. Just a reminder, of course, they didn't vote today. The vote will be taken on another day. It may come as soon as tomorrow. In fact, I am expecting it to happen tomorrow. So stay tuned and we'll try to bring you live stream coverage of that as well. And if the vote in committee is successful, then of course our application moves on to the full House for a floor vote. And with that, folks, I want to bring on Deanna Beckett, our regional director for Kansas. Deanna, what's your reaction to what you just saw?
Good morning. Oh, it's a repeat of the Senate hearing.
Yeah.
And I just love how our teams are professional and bringing almost expert testimony. I'm so glad that Michael Ferris was there to answer those tough questions regarding the litigation. But we only needed a couple of great testimony. And it seemed like the committee somehow knew Ben. I think they knew him and how he could answer the questions. It seemed to, take a little bit longer than we expected, but Ben was able to answer the questions clearly. And I saw a couple of questions in the feed, comments in the feed. I think it was on our Rumble, how they had never heard it answered that way before. So it was great to have just short testimony, a couple of people, and powerful testimony.
Absolutely. Our volunteers did a great job. And I do want to point out that Ben and the other gentlemen who testified are volunteers. They are doing this because of their concern and their passion for this country. They've done the research. They believe that the Article 5 convention process is the way to restore our federal system and get the nation back on track. So kudos to them. They were impressive. I was really proud of them. Deanna, what is the attitude of the Kansas team? Are they optimistic? How are they feeling? And what are they doing to prepare for the next steps in this process?
Absolutely. Kansas has been optimistic for the last couple of years, well, for many, many years. But, since we had originally, quote, passed, they have been working. One of the things that they're doing is focusing on the next couple of years. They're going beyond the final decision in the House, and their goal this year is to get another 5,000 petition signers. That is their goal is to get to 50. They've got that in their focus, and their next steps are, of course, looking at the House floor, praying for this litigation to come through. We need that judge to make the decision and make this easy to jump the hurdle of a simple majority rather than the 2/3. But they are working, and we're going to be doing some calls to action to ask their House representative to vote for SCR 1604. From the Senate to the House, SCR.
Yes, that's right. Well, that's great, Deanna. So if someone is watching from the state of Kansas and isn't plugged into this team or isn't aware of what they can do to help, what would you say to them? How can they get involved?
The easiest way is to go to conventionofstates.com/act. Producer G usually has that on the scroll down here. And that's the easiest way to get involved. To get in touch, you can find us on the Facebook page. You can find Kansas Convention of States on Facebook, YouTube, Rumble, wherever you need to search, but get involved that way. And you should be able to see a call to action coming soon. If you are a petition signer, you should see a email or a text coming to you in the next 24, 48 hours.
All right, Deanna. Well, thanks so much for taking the time to join us. And I know you have work to do, so we'll let you go.
Thank you.
And that's going to close our program for today. But again, I am expecting that same Kansas House Committee to talk about this resolution among themselves and vote on it tomorrow at around the same time as they convene today. So stay tuned for news about live coverage of that. And have a great day, everyone. Thanks for watching.